Good evening and welcome to day two of the 3 day Career in Intellectual Property Rights workshop. So, yesterday you all were there for the presentation by Dr. Anindya Sircar. He is going to continue from where he left yesterday and discuss about career in IPR for non lawyers today. So, I already did an extensive introduction of Sir yesterday. So, today, without further ado, I'm going to bring Dr. Anindya Sarkar on stage. And today, we will also have an extended Q&A session. So, make sure you put your questions in the chat. I'm going to look at them from time to time and I'm going to put them on the screen. So feel free to ask your questions and pick brains of Dr. Nindya Sarkar because today is the last day he will be presenting. So make use of this time. And with this, let me invite Dr. Nindya Sarkar. Sir, welcome to the live stream on day two. Thank you for joining us, and the stage is yours. I'll be around if you need me.
Good evening, everybody. Good to see you all again. And let me just bring the presentation up. Here you go. Okay. So, my plan today is not to present for full 1 hour. I'll present for a very short time, and I'm willing to take more and more questions. Hmm. Okay. Good evening. Many of you are responding. Good evening. Wonderful. Uh, I guess it's better to ask questions here because your questions is not going to help you alone, it's going to help others. Surprisingly, after yesterday's session, uh, I mean some of the participants are very, very, very resourceful. They I have received 19 emails. Okay. And out of the 19 emails, 11 of them were asking for certain doubts. We can discuss those doubts here, although I have responded to all of them. But it's better to discuss here because your doubt can not only help you, can help others. We can have a mixed opinion. And the rest of them were just looking for copies of the presentation. Can you send a copy of the PPT? Well, in that case, I would say, the live recordings are available for reference anytime, unless you want to copy content. I think you can and use it somewhere else. You can always refer back to the video which is available free for everybody, those who attend and not even those who are attending. So today I expect or I request that we have a more interactive session, okay, and move forward. Now I will just stop at one or two slides of yesterday to emphasize you a few points, maybe take 3-4 minutes and then move on. Okay. Today our focus is not only non-lawyers. Okay, I have certain slides. Oh man, I got the hang on, I got the wrong presentation. Okay, got the right one now. So let's move on. So this is what we discussed last time. I want to stop at uh some of the slides which are this one. I want to stop for some time. Now, what was I trying to emphasize in this slide? I was trying to emphasize that You don't have to always to be in a team which does IP and relevant to IP related activities. It is not always very important that you have to be a technical guy, you have to be a scientific guy, or you need to be a lawyer. No. Okay. If you look at the activities which are there, even accounting is there. Okay. Okay, so these are some of the activities, some of the skills which make it very, very complete. And in the life cycle of an IP, in the life cycle of an IP transaction, without any of these, if one or two is missing, you are caught. See, I have even put reverse engineering here. That is how you catch your competitor's product, try to find out what he has claimed in his patent is actually what is working. Look, the patent office are very filled with very nice people. They trust everybody. They are not going to verify what you have claimed in your patent from the technology point of view. Okay. They only look at novelty, inventive step, and utility. It is the duty of competitors to work out those patents and see if whatever has been claimed is appropriate or not, is correctly claimed or not. So there is a lot of R&D guys also work on them. Okay, you can also have a make. You don't have to sell it to others or utilizers. You can be your own utilizer and go for production and reinvest. The cycle goes on. Okay, this is a very very crucial slide in case of IP cycle, which covers everything. Okay, now the next slide where I want to stop is focusing. See, last day when we looked at it, we looked at it for non-lawyers. So, as a lawyer, what is the educational requirement if you want to be in IP? You not only require a law degree. See, a law degree in our country is not possible. Being a professional degree is not possible without an initial bachelor's degree. So you need an undergraduate and then a law degree, and then you need a license to practice. That means you have to be registered with the bar council. Okay, these are the requirements to practice for any lawyers. And in that, as a lawyer, if you want to practice as an IP professional, you need to fulfill them. Okay. Now, if a lawyer or a guy from the legal background wants to become a patent agent, the road is not same that he just walks in because he has got a law degree. No, the road is same for lawyers and non-lawyers. He has to qualify the patent agent exam. Okay? And the requirements are same. So a lawyer who has done a BLLB can never become a patent agent. Okay? And that's why the requirement of non-lawyers is so strong. To become a patent agent, you do not need a law degree. Got it? So even if a lawyer wants to become a patent agent, which is important in some of the practices, he must have a degree in science, engineering, or technology. So in case a lawyer is a BSc LLB or a BTech LLB, then only he can become a patent agent. So this area is primarily dominated in our country by non-lawyers. And there is a huge scope for that. Because most of the legal courses in our country is basically humanities based. It is BLLB. Although there are the other one which is very popular after this is BBLLB. But there are some law schools, very limited law schools, maybe I know of two national law universities and two or three private law schools who offer a degree of BSc LLB. The numbers are very small. So it's only for them who can become a patent agent. Okay. Now the requirements are same. You work in office hours, shadow a senior, uh, obtain your learnings from your colleagues, normal lectures, master's course, become an agent. There are postgraduate diplomas and lots of reading. So the training and other thing doesn't change. Okay, it remains the same. Now, what you see on the right are the options which I gave yesterday for non-lawyers. Private practice, industry, examiner, paralegal, academics, research, consulting. A lawyer can also do all of them. What he can do over and above that is court practice, litigation. A non-lawyer cannot take up an IP litigation. He can do all the other things. If he is a patent agent, he can represent the case in the patent office. He can argue there. He can oppose there. He can attend hearings. He can attend appeals in the patent office. But as it moves to the court and there is a litigation happening, litigation on the validity of an IP, on the enforcement of an IP, or on an infringement matter, this area is dominated by lawyers. So if you don't have an LLB degree and don't intend to pursue an LLB degree, okay, keep in mind that you will not be arguing in the court. Or let me tell this in another way. If you don't want to argue in the court, don't want to get into legal suits, you do not need an LLB degree. All other functions can be done without that degree in terms of a career in IP. Okay. Employment areas remain same. Now, if you are looking at litigation, what are the areas of IP litigation which are normally common? Okay. From the lawyer's point of view, mainly this is the number of cases, if you look at it, the maximum cases are on infringement. The numbers are not very high in our country, but it is rising by leaps and bounds. To that extent that we have special courts which have benches dedicated to IP. Okay, the Delhi High Court, the Chennai High Court have dedicated benches, dedicated judges who listen to only IP cases. Okay. The number is on the increase. I am very confident that with time we'll have more dedicated benches in courts would be dealing with IP matters solely. So infringement can be in patent, trademark, trade dress, trade secret, or copyright. There are litigation on validity of patents. There are other related disputes on ownership, publicity, database protection, domain name disputes, data privacy, and security breaches. So these are the common IP litigations which a lawyer can take. In the prosecution, the work remains same as for lawyers and non-lawyers. Okay. Now, search analysis and all this, so it requires a different frame of mind, a different skill, different attribute. Being a lawyer or not being a lawyer doesn't make much of a difference. It is the skills which are required, okay, which one develops with time. Okay? Mainly the prosecution matters. We have looked into this. There's no changes. Now I'm coming to some aspect which is a mix of law and non-law. In today's world, there is a lot of technology transfer which happens. And technology transfer is basically nothing but IP transfer. Okay. You cannot transfer a technology if the IP is controlled by somebody else. Your technology will have a lot of problem in surviving and in going forward. Now, what are the various aspects of technology transfer? Any technology comes from R&D, which which could lead to an invention, or it could be not that every time it leads to an invention. It could also be a Me Too technology for a Me Too product or for an existing product. You come out with a process to manufacture it. Or you could be actually following a standard process which is known, or a process which, from a patent which is expired. Okay, once in the case it's a niche and a new output, we reach something which is known as an invention. That invention needs to be evaluated, and if you find it has an IP which can be protected, then the IP needs to be protected. And after that, you can use the IP for your own satisfaction, your own purpose, your own commercialization intent. In case you want to transfer it, that comes then it becomes a marketing activity. Okay. Although you will be marketing and selling the technology, in reality you will be licensing the IP. Okay. And the product development can happen in-house or can happen after licensing if you have reached a stage which we say POC, proof of concept, and then you commercialize in public use. So this, by and large, are the simple steps of technology transfer, and it's very IP oriented. And the aim of this technology transfer, development, and all this research, development, invention, IP, it is not progress of science. Okay, we are not talking about academic research. We are talking about commercial research. That research should lead to only one thing, which I'm showing here. It should lead to money. Otherwise, this is a very straightforward academic research for which there is no need of any conversation. We all know how to handle that. Okay. Now, when we took a commercialization, there are a few points which I thought would be interesting, and they are like, what are the steps and what are the places where somebody who's interested can put in these efforts and build a career. There is a pre-invention stage which mainly involves of making the IP strategy. That means how your invention should churn out. Okay, how should and scouting for other inventions in that landscape, coaching and finding to fill up gaps. Okay, this is an ongoing process. It never stops because a product is not static. Research never stops even when the product is commercialized. People keep on working on it, try to improve it. Then we have an assessment stage where you like to see that, do I really have an IP, or I just have a product or process? If you see that you have a product or process which is like anybody else, then the commercial structures are low, the stakes are low, your money, your aim is much less. So, in this assessment process, we look for patentability, we look for commercial potential, what are your rights, okay, and the related contextual matters. Once that is done, you are now ready that, no, okay, fine, I want to commercialize my IP. Now, this commercialization would first require to have an ownership. What I mean have an ownership is that you first need to protect it. Okay. See, if you build a house, you cannot sell that house or you cannot give that house for rent until the house is registered in your name. Simple. Okay. So here also you may have an IP. It needs to be protected and registered in the name and given a proper ownership. It is only when the proper ownership has been established that you can move forward to make money out of it. If you want to stay in your own house, you can delay registration because it's not a commercial activity. It is utilizing your own asset. So the first step in case of commercialization would be having an IP protection. Okay. Then you do the business charting out of it. What kind of models, what kind of assignments you want to do, what kind of license you want to do. Okay, build a team, and then work on different license models and agreements depending on what other clause you go or not go. Now, I'm talking about the commercialization step, but this is not a necessary step. Not that every IP which is generated needs to be commercialized. It can be utilized in house by the organization or by the individuals who have developed it. In that case, even if you do not commercialize, I would suggest that you make a complete protection cycle, okay, and get it registered in your name. So the ownership part is established. Tomorrow somebody else cannot come up and stop your business. So business sustainability is also important. In case you're not commercializing, you want to use it in your own. In both the cases, my suggestion would be to go and have it registered. Okay, it's like that. You build a house. In even if you are the only one who is staying in that, you can you still need to register it in your name. Otherwise, there can be issues which can be cropping up tomorrow. Once you have gone through this, there is a post deal management also which is required. Okay, you need to manage the IP which has been licensed. Okay, you need to maintain the IP which has been licensed, and you have to also take into account the finances which you need to spend in such management, and also the finances which you expect as a business return. Okay. Here, the most important part comes in is that since research is never static, research is very dynamic. What happens in the long run is you get new IPs being generated. There are process improvements which come in. See, when you licensed, when you commercialized, it was about what existed 2 years back. Now, today, after 2 years, things have changed. Now, how to use them? What is the articulation in the contract? How that can be used? Or do you really want to give improvements, or you don't want to give improvements as well? Okay. So there, when you talk of IP, hmm, there is something which is known as, when you're doing a licensing program, there is something which is known as background IP. That is the IP which exists today. After today, there may be additional IP being generated on the same system, which is known as foreground IP. It is important to articulate in contracts that how this foreground IP will be dealt. Okay. So in this process of commercialization, there are 6 different themes which are necessary. Okay. First of all, Of course, IPR, because we are talking about IPR, you need to also understand the market, the demands, who are the users, who are going to mm, license your product or process, whichever has come out. You have to understand the technology, where your technology starts, or are there competing technologies there? Okay. Finally, in the commercial market, it does not matter when you buy a product. Okay, it is utilizing which IP and from where which method it is made. If it's the same product or a similar product, so you are fighting with competing products. That's when the technology comes, and that technology and the market leads to your business. Your business needs are governed by these two, okay? And you make a proper business plan. And for all that, you need a proper team to work, and you need a proper funding to keep this rolling. Okay. Now, from here, if I just move on to the next step, okay, आईपी हो गया, बना लिया, कमर्शियल लाइसेंस कर दिया, then what? Life doesn't end there. The same team, the same guys needs to be working furthermore on the market and business for a long time. And for that, you need to have a separate marketing plan, maybe a separate long-term business or a short-term business model, and you need a team to run that. So that, and to make it happen, you first need to define your value proposition, take a look at your stakeholders, validate your market from time and again, define the path. Path, here are two paths to be defined: path of your commercial market and the path of your technology. Today you may have an excellent IP doing great. Tomorrow there's a new technology in the market, so all your efforts may not be that relevant in the market anymore. And to do all that, as I have said earlier, you must have proper non-disclosure agreements to discuss. In a negotiation process, I'm just trying to give you a brief overview how things can work. So when you confirm that you need a to have a license, you are going to give a license, fine. So the parties, there is a party who's interested in giving a license. There's a party who is interested in taking a license of the IP, which we call the licensee and the licensor. So we have an initial dialogue which establishes that, okay, fine, we are going to have this kind of a deal. So we define the deal type, whether it is going to be exclusive license or a non-exclusive license or a complete assignment. Based on that, you come to know what we call is a term sheet. Term sheet is not totally binding. Okay, it's an overview of the deliverables from both sides, from the technology side, from the commercial side, and also from the payment side. So you agree on the term sheet, and then is the negotiation which happens, okay, based on what you have agreed on the term sheet. Now, this is, as I told you earlier, this is not like buying stuff in the mall, like a fixed price shop. It is like buying vegetables from the vendor. There is a scope for strong negotiations. Once you agree on those, you draft a license, sign or execute the license. Job is done, but there are some post deal activities which needs to be monitored and managed, which we keep on doing for a long time. Now, like yesterday, I said, IP management is a hidden profession, a hidden career for all STEM professionals. Here today, I'm saying, practice of IP is an exciting practice area for attorneys. Okay. Now, having said that, I think we should have more questions uh, till we move. Okay. So let's take some questions. Are there any questions already there? So, because I wanted to speak for half the time today, I've spoken for a little more than a half an hour, so we can have a discussion for next half an hour. So, there any question I can see? Siddharth Nayak has got a question. What does Siddharth say? Siddharth says to get a wider approach over the domain of technology for a researcher, are there any resources of readily available technology, pattern mapping reports in the domain? Yes, there are. Siddharth, there are. Okay. There are proper domain sectoral reports which talks about the pattern, the technology, the revenue, the potential, etc., etc. Okay, they are done by several firms. They are commercially available. You need to buy them. See, nobody will do that entire work and mm, and give it to you for free. So there are various organizations, various firms which do that for a living. But having said that, I would also like to add one more point here. Since this is a dynamic area, things keep changing. It's not that today evening, tomorrow morning things will change. That's a very drastic change. It doesn't happen usually. But things do change over the time. So even if you're getting a report, look at the last date of the report and uh, do your homework to see that if things have changed after the report. I personally feel that instead of buying reports, because these are not very cheap either, instead of buying reports and doing all that, you can generate your own report, and that might prove to be more beneficial to you. Okay? I hope I could add some sense to that. Okay, Gagan has asked something above. Let's look at what Gagan has asked. Gagan has said, what is the role of an IP lawyer in M&A? To the number of lawyers having tech background are less. Why is that the starting salary are these are basically philosophical questions. What is the role of an IP lawyer? Okay, IP lawyer in an M&A, definitely IP lawyer has a role. Uh, I would say that I would not use the word IP lawyer. I would like to use the word IP professional. He could be a lawyer, he could not be a lawyer. He need not be a lawyer. There is a huge scope for both, and there's a huge need for both. Okay. See, ultimately everything is defined through a contract. Okay, the deal. That contract needs to be drafted and negotiated. So, if you think a non-lawyer can do it as good as a lawyer, you're free to use a non-lawyer. Okay. It's finally, in M&As, license, in license, it all ends up to that contract, which needs to be properly drafted. The contract is not just, not transferring this. There has to be background IB, foreground IB, mediation clauses, arbitrations, representation and warranties, various subsections are there. If you feel, this can be done very well by a non-lawyer, fine. There is no rule or statute that it has to be done by a lawyer. Since lawyers are more accustomed and attuned to doing drafting contracts, Okay. They are popularly engaged. That answers your first question. The second question, the number of lawyers having tech background are less. Why the starting salary? I don't think this is fully accurate. It's a varying stage where you get in. Okay. Now there are small companies, there are startups, there are mid-sized companies, there are big companies. The starting salary is not same everywhere. Okay. If you get into a startup, you will be more prone to have more equities than your salary. But if you go to an established company, obviously, your salary structure will be better than the smaller one. Uh, No wonder people change for their profession from small companies to bigger companies. Salary is one of the factors. There may be other things. So, why is somebody's salary low, and why some organization giving a little higher salary? It is again the market rules. There's I cannot give you an answer. Now, if you are saying is there a poor patent ecosystem in India? Well, Indian patent ecosystem has improved drastically. You have no idea when 30 years ago when I started practicing in this area. Okay, there was no ecosystem. I couldn't explain to people what is the meaning of IPR. When I spoke about IPR, they used to think it is interpersonal relationship. So the ecosystem has improved. Okay, media has played a very important role in educating people, sometimes correctly, sometimes not so accurately. So it is improving. It is again a demand. Remember, our system got our patent rules got the first major revision in 2005 through an ordinance. And before that, there are various sectors where the business is very strong. Our patent act did not allow the presence of product patents. There were only process patents in certain sectors. It is only after 2005 when things started changing. So that as a result, there are uh, not that many activities which has innovations which have been protected in that manner, which could lead to conflicts and litigations. But it's improving. Okay. Now the question is, you want to compare the patent ecosystem of India with US? It is like it's like comparing apple with oranges. You cannot compare them. Is the ecosystem better there? Definitely better there. Okay. So let's look at some more questions. Okay, Sukumar says, if a lawyer got a license as an IP lawyer, there is no separate license for an IP lawyer. There is no separate license for a civil lawyer or a criminal lawyer. You are a lawyer. How do you get it? Get a LLB degree. Enough. You want to do a post graduation, get an LLM? Your wish. Not necessary to become a lawyer. Most successful lawyers in our country do not have a master's degree. You are a lawyer. Now, which area you want to practice? You want to practice family law, you want to practice labor law, you want to practice IP law, is your choice. There's no separate license for that. And there are some lawyers which practices in multiple domains. Okay. Civil and criminal, IPN, maybe data security, IPN, maybe also some civil cases. So since there is nothing like that, so you just have to keep your lawyer registration valid. That's enough. Nothing more for as I say, for a IP lawyer. Gagan says, please recommend a few certification for IP. Okay. Gagan, you are an IT person. It appears to me you are from the ICT background. Hmm. Now that's where the most certifications are required because that helps in their. So there is a lot of certification, which Gagan also says yes, because that certification mentality is actually from the ICT background. It helps them in their work, um, and it's good, nothing wrong. If you look for a certification in IP, the point is uh, it is more of learning, I would say. What are the skills you have acquired? And there are, when you acquire a skill from a legitimate place, they do give you a certificate. Like, today, the last 2 days, we are doing a awareness program. And if you want a certificate for that, we are providing you a certificate. Okay. But if you really want to go into the depth of learning, you want to learn in depth about patent laws, or you want to go in depth to learn about cyber law and the related IP, then you need to do a much more intense course. There are diploma courses, postgraduate diploma courses, which are available by some of the law schools, hmm, and also from a couple of private enterprises. Now, these are usually, some of them are in distance learning mode, some of them are physical modes. You can look at the specified areas. Usually, certifications are very small courses, they touch in the surface. These diplomas are far more into the depth. Uh, I can give you, say National Law School of Bangalore, or NALSA, which I represent. We do run diploma courses on various aspects of IP. So I'm not promoting or recommending any of those courses. You can go to the websites of these different institutes and find something which suits you and take it forward. And I can tell you, just a couple of certifications, unless the skill is acquired, you may not be of just, it is not PMP certifications. Okay, it's not, may not be enough, just enough. Okay, now let's move on to what Sumeshwar is saying. How will I know that someone has filed a patent, the technology which I am already using? Do a patent search, Someshwar, and that's called a prior art search. You can do it yourself if you want, or there are agencies and companies who will do a search using a specific syntax or a search string. Now, where do you do this search? You can do this search in a lot of free databases. You can go to the patent office website and carry out a search, or you can do in multiple patent offices. There are databases available which has coupled such information from multiple sources, both patent and non-patent literature, which is available on a subscription basis. You can choose to be a member or subscribe to some of those databases to know that. See, this is a very, very vital question in the sense that unless you're sure that you have an IP, you cannot make the rest of the plan. And for that, a prior art search is very, very important. Okay. Like if you want to search the Indian Patent Office, you can go to patentoffice.nic.in. Okay. If you want to search US patents, you can go to uspto.gov. If you want to search European patents, you can go to eSpaceNet. Hmm. And this subsequently, or there Google also offers a platform which is known as Google Patents. You can search there as well. He has a following question that In case I come to know of someone has filed for an IP which I already using, hmm, now this is a very complicated question. You come to know that you have an IP which somebody else is using. Now, if your IP is registered, then this is a case of infringement. You can sue him. Okay, you can send him a legal notice, settle, or take him to court, provided your IP is registered. Now, in the case you have an IP and you have not registered, you cannot take any action. Since you have not registered, you can not take any action, and anybody in the public is free to use rather, if you say copy, you can or get influenced, get inspired, you're free to do that. So that's the importance of registering an IP. Next, I couldn't attend yesterday. That is, Rahul will take care of that. Gagan says that I am doing LLB in NLS Bangalore. Had IP courses from, okay, Arul's. Okay, Gagan, Arul Zakaria is, I think you're talking about Arul Zakaria. He's known to me. He's a good friend. He's a good teacher, and he's an expert in copyright. So I'm sure that you will be able to learn a lot from him. Okay, so looks like you are doing that the new 3 years LLB which NLS has started. Since you have already done an engineering course, you are not from the mainstream clad background. Okay, good to know. Good to know. Okay, now do we have any more questions? Not right now. I think we still have about 10 minutes time. You can ask, or Rahul, do you want to pitch in
Yeah,
those
yeah.
points?
Yeah, sir, I have some questions. So, first, I'll tell the audience that we have 10 minutes. Please feel free to write your questions on the chat, and as per the time, we will answer it. So, sir, my question is regarding IT related inventions and maybe specifically AI, which is coming. So, is there a scope that this will increase the number of job opportunities in kind of IP specifically in India? Because as such, we are not uh, thinking of them as inventions. So, so what's going on currently, and with the talent that we have in IT, can we use that in IP?
Well, if you really want to see, AI is gradually entering every field. Now, from an IP practitioner's point of view, I would like to use AI as a tool to help me. Okay. Help me in taking certain decisions, help me in doing some paralegal work, help me to do a prior art search. Okay. May not be that much of decision taking. So AI has, I don't feel it's reached that stage where AI can take decision or AI can replace a judge. Oh, okay. When it comes to parking taxes, tickets and all, it's fine. That AI can manage, but not more than that. When you're talking about real hardcore technology, in that case, I would like to use AI as a tool. Now, if I want to use AI as a tool, obviously, you need to develop such AIs. You need to develop such AIs which are specifically enhancing the lawyers.
Mhm.
There are certain tools, like there's a tool made by IBM which is known as Watson. Now, Watson has got many um, prongs of uses, but the main aim of Watson is for the medical practitioners and the legal practitioners. It's good. Okay. Now, The way, if you ask me that I need to write an assignment or an article, then I use ChatGPT. Well, then that's not creativity. So we have to live with that kind of nuisance also.
Mhm.
It is going to come. See, as a teacher, I have to be very cautious when I get assignments.
Mhm.
Now
And
open AI or generative AI sources which can also humanize report created by ChatGPT. Okay.
yeah,
Now the idea is not to get evaluated and get a high marks or a high grade. The idea is what is the skill I am acquiring from it, which I can be use it in future.
mhm.
And as see, there's a lot of controversy on AI in the sense that can AI be an inventor? Can AI be an author? Mm. See, AI being an inventor, it has been ruled out both in
Yeah,
Europe and in US when there's a application filed for in the name of Davos. But then some of you will point out no, but it got granted in South Africa. It got it granted in South Africa because South African patent law does not require a substantive examination. It requires only a formal examination. So it
mhm.
might lose out the moment it gets challenged. Now, can AI be an author? So I can hook onto a website right now, give a theme, give a few words, and request the website to create a poem for whomever I want. Now, once that is created, who's the author? Who holds the copyright?
Mhm.
Is the machine the author now, or I have given some input? I am the author, or the developer who made the program, he's the author. Now,
Mhm.
these are certain gray areas which are not really cleared. But about
Mhm.
4 to 5 months back, there was a very good article in a scientific journal. I don't know how many of you read that. It's a very popular journal called Nature. Okay, Nature made a review where they showed that there was co-authorship given to machine in articles. Okay, now these things are it's only a matter of time how we need more litigations to clear
Yeah,
this out.
to clear this out. Yeah. So, sir, there are few questions. Maybe let's take one question at least for Someshwar Rao. He's asked one more question. I think it's related to if a person, if a PhD person files IP for the technology they have developed, will it go jointly in the name of the supervisor and candidate, or only in the name of the candidate?
Mr. Rao, this is again a policy and non-policy question. Uh, if you look at the law, the Patent Act, and you want to file a patent which is an output of a research activity, there are two names which are important. First is the inventor. Okay, who is the inventor? The inventor is the person who has contributed to the claims of the invention. Now, if the supervisor and the candidate have uh, both contributed, so both become inventors. Okay, now this is substantial claim. Now, if some technician has done some analysis or done an NMR or injected for an HPLC chromatogram, he is not an inventor. He is doing a routine job. Who has substantially contributed to the claims become an inventor. Now, inventors will be always counted as the people who made this invention. There is one more term which comes in patent law, that is the applicant. The US system calls it the assignee. The rest of the world calls it an applicant. The applicant is actually the owner of the patent. Now, this is very, very uh, ad hoc. Now, who's going to own it? In most of the cases, I don't think neither the PhD student nor the supervisor will be owning it. It might be owned by the institute because that's the policy of the institute, or it might be owned by the funding agent. If your project is a project from DST, DBT, somewhere here, there, so when you took the grant, you agreed to that, you will find that it is already written that all IP generated will be owned by the funding agent. Of course, you have the first right of refusal to use it. But there are also, royalty sharing clauses in those agreements. CSR usually has a 60-40 sharing with the research team and the funding agent, that kind of. So that is so one thing I can say, as far as inventors are concerned, there is nothing to worry. Both of you can be inventors. Applicant, who's the owner, is usually the funding agent.
Mhm. Yeah. So maybe one last question. Maybe I think Nagendra Kumar and Chaitra, sir, can we transfer technology before filing a patent?
You can always do that, but that will not be a very smart way of handling. Hmm. Because your prices will be less. It is like, when you have a semi constructed house, you sell it, and you have a fully constructed house, you get more price for the fully constructed house. So if you have not filed a patent, hmm, you can see nothing stops. There is no hard and fast rule that you cannot transfer technology. Anybody can transfer technology at any stage. Okay. The price will vary. So the more you are towards, because two things. Okay. One is, the, if you have filed a patent, you completed your POC, the risk for the buyer is less. So he is willing to give you a higher price. If you are doing at an early stage of technology, there could be several uncertainties. So the price will be low. So it's a choice. So nothing stops you. You can transfer technology at any moment.
Mhm.
I think
Amazing.
that answers the question, Nagendra.
Yeah, we are also kind of out of time. I think I'll take, sir, these 2 minutes to thank you. Really honored to have you in our platform, and all these questions, they were answered in a super accurate way. So it's a seemingly simple question, can technology transfer be done before filing a patent? But you see, this is the implication, right? You have to it's like before completing the house, or when the house is in construction. So great. I want to thank the audience. We are at the end of day 2 of the career in intellectual property rights workshop. Tomorrow I am going to share my own experiences. I've been working several years in patent research, patent consulting, and I'm going to share my experiences. What are the skills that I learned during my time, and which I think will also you can also learn those skills from various short term online courses which are available, and they will significantly boost your understanding and about the field, as well as your chances of getting a good paying job. So yeah, like patent search, these kind of have knowledge of patent concepts, simply like claims, citations, classification, all these things. So we are going to meet tomorrow. With this, we'll say goodbye. I'll say thank you once again, sir, for joining us for
Very much.
two sessions.
I enjoyed it equally, and I love such sessions. I love such sessions. Okay, so I'm sure we'll be meeting again someplace, somewhere, and we'll continue this journey of improving the IP ecosystem. Thank you. Have a wonderful evening.
Thank you, everyone. Thank you. Bye bye. See you.